Senator Ebbin.
Thank you, Mr. President. Speaking to the bill.
Senator has the floor.
Or actually, would the gentleman from Grayson yield for a question?
The senator from Grayson yield for a question.
I'll yield.
He yields, Senator.
I would ask the gentleman, where in the bill does it say that marriage celebrants under the code section reference, including judges, can't refuse to solemnize marriages of interracial, interfaith couple or interfaith couples because of their sincerely held beliefs?
The senator from Grayson.
I don't know that it does exempt them. I like to refer to 20-13 is a section of the code in which individuals are licensed to recognize the fact that they have the ability to marry.
The senator from Alexandria.
Would the gentleman yield for another question?
I'll yield.
He yields, Senator.
To follow on the senior senator from Enrico's remarks, would it not be allowable by saying that no person authorized to perform a marriage shall be required to solemnize any marriage, and then no religious organization and so forth shall be required to do X, Y, and Z? Would that not be allowable to deny otherwise protected classes in violation of the policy of the Commonwealth to safeguard individuals from discrimination as set forth in the Human Rights Act and the Code, including people of color? Would it be allowable to deny those people perhaps access to a church hall that's otherwise rented to the members of the public, except for X or Y type of people?
Senator from Grayson.
Mr. President, I would answer the gentleman, there is nothing in this code, nor today can they deny that of a protected class. This is a religious organization, and under their religious beliefs, simply the fact that they're sincere held beliefs, that they do not have to marry a couple outside of that belief.
Would the gentleman yield for another question?
Senator, yield for an additional
I'll
question.
yield.
He yields, Senator.
So if I understood the gentleman correctly, that based on sincerely held religious beliefs, that anyone could refuse to either marry or a group could refuse to provide their accommodations if they said it was sincerely held religious belief. And I would ask further, would the gentleman agree that that this bill would grant any sitting judge or justice of a court of record or any sitting judge of a district court the right to refuse to solemnize a marriage on the basis of privately held religious beliefs, whatever those beliefs are?
No.
Senator from Grayson.
I'd answer the gentleman that he is just trying to confuse the section, and it has nothing to do with any protected class, and it only applies to religious organizations that it states in the bill, and a person who's licensed, if that judge is licensed, then yes, if he has a deeply held religious belief, as I said in committee, you can't, an individual has a deeply held religious belief, and if you're wanting that person to violate that, then, you know, we might as well not have a section of the code or a constitutional amendment that says that an individual can't be forced to do something, as Jefferson wrote, against that religious belief. And I would answer the gentleman that all these questions directed toward discrimination are not in this section, and that it is just trying to confuse everyone about what this bill does.
Thank you, Senator. The senator from Alexandria.
Speaking to the bill, sir.
Senator has the floor.
First, I'd like to thank the gentleman from Grayson. I think he just clarified that judges, who I consider public actors of the state, could discriminate on closely held religious beliefs. In the same code section where it refers to these religious figures, it is very clear that judges are included. And I want to be clear that the state should not, and under existing law cannot, force clergy or houses of worship to perform or host marriage ceremonies with which they have religious objections unless they hold out those public accommodations to all members of the public. I think this bill is clearly unnecessary. Virginians are already well protected against government discrimination based on religion by the Virginia Statute on Religious Freedom, and further by the Religious Freedom Restoration Act, which forbids government entities from burdening a person's free exercise of religion. It would grant any judge, as I said, explicit authority. It says judge in that code section to refuse on the basis of their privately held religious beliefs. These are judges paid by the Commonwealth, authorized by the Commonwealth, elected by this body. These are public people we're allowing to discriminate based on their privately held religious beliefs. It sanctions discrimination by government employees. It's a solution in search of a problem. We are the birthplace of the statute of religious freedom. We enjoy one of the richest histories of any state when it comes to that freedom. It is core to who we are as a Commonwealth. Proposals like these, licenses to discriminate, they desecrate the very thing they claim to protect. Our rich history continued just weeks ago as this body voted to prohibit discrimination in two aspects. Yet, it remains perfectly legal today in this Commonwealth for a gay person to have a civil marriage at noon, or any marriage at noon, be fired at 2 and evicted at 4. No matter what action we take today, we cannot stop what Jefferson called the progress of the human mind, and his strong belief that laws and institutions must keep pace with the times. This bill would certainly carve out a space for bigotry cloaked under the guise of religious freedom.